Welcome to Danni's Den, and today we will dive into the issues of the day regarding love, parenting, sports, and/or pop culture. Let's chat.
Picture Sunday. Jerseys on, snacks lined up, the kids cheering for the opening kick or first pitch. Now imagine one parent says, calmly, "I've been offered a job across the state." The room goes quiet. That football or baseball ritual suddenly feels fragile.
So, can a parent actually relocate with the kids? The short answer, sometimes. The longer answer depends on notice, consent, and what a court thinks is in the child's best interest. I'll walk you through practical steps for both sides and give 3 quick parenting moves to protect routines.
Quick real-life picture. I once helped a parent who learned about a move the week before school started. The child lost friends, missed an important orientation, and the non-moving parent felt shut out. Nobody wanted that outcome. That's why timing and a plan matter.
Okay, legal reality check. Family law changes by state, but think in plain terms. Who decides? Did you give notice? And will the move change custody? Those 3 things shape what happens next. Who gets to decide? Usually it's the court where the child lives now. Do you have to tell the other parent? Often, yes. Notice rules exist to prevent surprises. And no, you generally can't just pack up the kids if the move would change custody or visitation. Courts use the child's best interest as the compass. That covers stability, school and community ties, the child's relationship with each parent, and practical travel concerns. Judges also ask, why is the move happening? Job? Family support? Safety? Those reasons matter, but the effect on the child is what usually tips the balance. Consent matters. If both parents sign a written agreement, many headaches vanish. If one parent objects, you'll often see filings, a push to mediate, and sometimes a hearing. Emergency orders are uncommon. They require real immediate risk. Now let's get practical about paperwork. If you're the parent proposing to move, collect school records, a proposed parenting schedule, proof of the move reason, and a travel plan. Put it in writing. Don't handwave. Show specific dates, who pays travel, and how holidays will work. Concrete example. Aim to give 8 to 12 weeks notice when possible. Offer a sample schedule. For example, 2 weekends a month guaranteed. Every 3rd weekend, the child travels with costs split, and summer custody extended by 2 weeks. Lay out holiday rotation. Odd years Thanksgiving with parent A, even years with parent B. Specificities build trust. Make a simple relocation proposal. 1-page summary up front, then a short attachment with dates, school plan, and travel logistics. Think of it as a child-first FAQ you give the other parent. That reduces friction and reads well if a judge ever sees it. Let's talk about how to say this without lighting a fuse. Start with empathy and I statements. Try, I know this affects you and the kids. I'm sharing my reasons, and I want to propose a plan that keeps your time consistent. Keep your tone steady. It's easier said than done, but tone shapes the rest. For the kids, keep rituals obvious. Bedtime stories, pre-game snacks, the playlist, those small things travel well. Make a visible game day calendar. Let the child help pick 2 songs for a shared playlist. Those tiny anchors give them continuity when everything else is changing. If you're negotiating, specificity is your friend. Offer trade-offs. Extra summertime, guaranteed video call after every away game, or paying for certain travel nights. Specific promises reduce suspicion. And if communication stalls, suggest mediation before calling lawyers. Now, a word for the non-moving parent. If you object, document clearly. Keep a log of current visitation, school stability concerns, and any professional notes if the child is in therapy. That record helps show what would change if the move happens. Temporary or emergency orders are available, but only when there's immediate risk. Don't rush to file unless you need to. A measured, organized case preserves credibility in court and in mediation. Mediation versus litigation. Start with mediation. It's faster, cheaper, and parents keep control of the outcome. A neutral can help craft creative solutions a judge might not order, like a rotating live game attendance plan or a tech-enabled weekly ritual.
Okay, now the part I know some of you live for. How do we protect Eagles and Yankees weekends when a move splits the map? First, calendar rituals, so everyone knows who does what. One parent keeps Saturday night prep for away games, the other keeps Sunday pancake mornings. Consistency wins.
Use technology. Stream games together, set a regular post-game debrief video call, and create a shared playlist called Our Game Day Mix that travels with the child. Small shared rituals equal big emotional continuity. Quick do and don't list. Do give notice. Write a clear plan and offer specifics. Do try mediation. Do keep the child routines front and center. Don't surprise the other parent. Don't make promises you can't keep. And don't let anger drive logistics.
Recap in one pass. Moving? Prepare an 8 to 12-week notice, a one-page summary plus detailed schedule, and a travel and holiday plan. Objecting? Document, ask for mediation, and use temporary orders only for urgent risk. Keep rituals, bedtimes, playlists, and game days obvious and shared.
If this raised specific legal concerns for your family, please consult a local family law attorney. Laws differ by state, and every family's facts are unique. You can also use the show contact page to share a general question. And if you found this helpful, subscribe to Danni's Den for more straight-up legal clarity mixed with parenting tips, sports rituals, and music picks. Let's chat.
Thanks for listening to Danni's Den. Take care of yourselves and the kids. Keep those playlists handy, and I'll see you next week. Let's chat.